Hey guys, welcome back. Gabby Zan is here and we're here with Gov with Gabby. So if you love AP Gov, just to start the video out, make sure to subscribe, follow, turn on your notifications for more of our videos. Today, we're going to be talking about Schenck v. United States, a required Supreme Court case for the AP Gov curriculum in 1919. So let's get right into it. Charles Schenck and Elizabeth Baird, these were both socialists, and they distributed thousands of leaflets urging draft-age men to refuse the mandatory draft requirement for World War I. A lot of people were against this war, but they actively handed out leaflets, arguing and urging people to go against the law mandating military draft. They declare that this military draft, it violates the 13th Amendment. The 13th Amendment, just a flashback, started after the Civil War with Reconstruction. It was one of the three Reconstruction Amendments, 13 and 14, 15, just for a quick review. The 13th Amendment abolished slavery, or involuntary servitude, and it argued that the draft was also comparable to slavery. Schenck and Baird simply handed out pamphlets urging them to peacefully protest the draft, but still they were convicted of violating the Espionage Act of 1917. The defendants argue that their activities are protected by the free speech of the First Amendment. In the Bill of Rights, there are several liberties laid out to individuals, including free speech, right to religion, right to peacefully protest, a bunch of different rights, and one of them does include free speech, and they argue that their handing out of pamphlets was a form of speech, protected under the First Amendment, and that the Espionage Act is unconstitutional. So the big question, the big issue here, is are the publication and distribution of literature urging resistance to a military draft, is this protected speech under the First Amendment? And then, is the Espionage Act of 1917, is this constitutional considering the First Amendment and what it entails? So what does the Supreme Court say? It was a unanimous decision, 7-0, for the United States against Schenck. They said that the free speech clause of the First Amendment does not shield unlawful conduct under the Espionage Act because there is a certain authority that the United States has, the government has. During peaceful times, it's a little less, but when it's wartime, it is game time. There is no time for any messing around, anything that could mess up the laws of the United States. The United States has to keep order during a time of war. This is a time when there's a lot of different opinions. We are literally at war with another country, so the United States has a tighter hold on their laws and the people of the United States. So, the Supreme Court holds that the Espionage Act does not violate the First Amendment, and it is an appropriate exercise of Congress's wartime authority. Since they are in war, they have a tighter rein on their laws and what is allowed. So, the Supreme Court ruled in favor of the United States versus Schenck because the Espionage Act was constitutional and it did not go under the free speech clause of the First Amendment under wartime authority. Now, what is Schenck versus the United States? When you think about Schenck versus the United States, you have to think of clear and present danger. Clear and present danger. This says that if it will cause a substantial harm, it being your free speech, then the government has a right to prevent it. A common example is shouting fire in a movie theater. This could cause sufficient harm to the people around you, panic, disorder. In this, yes, you have a free speech. You're allowed to say what you please, but in a certain limit. You can't do anything that will present a clear and present danger. The First Amendment does not protect speech that creates a clear and present danger to either an individual or the nation. It's very important to note, which I stated earlier, that the Supreme Court says that the defendant's activities, so Schenck, must be interpreted in the context of war. The United States has a tighter control of the country during wartime. During peacetime, the activities might be found to be protected because peacetime there's more leeway. But during wartime, the widespread dissemination of the leaflets, it may have led to a lot of people protesting the draft, which would go against wartime protocol and wartime law, which was vital to the success of the nation within war. A more modern analogy for today might be the prohibition against falsely yelling bomb on an airplane. This creates an obvious, clear, and present danger. Whether it's shouting fire in a theater, urging people with leaflets to not engage in a military draft, or falsely yelling bomb on an airplane, these are all forms of speech that present a clear and present danger that are not protected under the free speech clause of the First Amendment. Thank you all so much for tuning in. If you love this video, learned a little bit about Schenck v. the United States in 1919, or you just want to learn a little bit more and love AP Gov, Make sure to subscribe, like the video, and turn on your notifications so you can hear all the other court cases that are required for the AP Gov curriculum. Thanks, guys. Bye!